Hello everyone, my name is Mahika Gaur and I'm a first year student of General Global Law School. I am currently interning under Sejpal Associates and Advocates, and today I will be discussing the case of Vishaka versus State of Rajasthan. Apart from a general discussion, I will also be talking about the various guidelines that were provided under the judgment. Vishaka versus State of Rajasthan was a landmark judgment that gave way to certain provisions for sexual harassment in the workplace. It was presided by judges J.S. Verma, Mrs. Sujata V. Manohar, and B.N. Kirpal. Let us first look at the facts of the case. Now, Banwari Devi was a social worker in Rajasthan and she was working for the state government, which is under the Women Development Project to stop child marriages. And she tried to stop a child marriage in Ramkaran Gujar's family. He was marrying his daughter at the age of 1. And she was successful partially on that because on 5th May 1992, the subdivisional officer and the DSP went and stopped the marriage. However, the marriage did happen the next day, in the next few days. With the establishment of the police visits being the result of Banwari Devi's intervention, she was boycotted and lost her job. And apart from this, on 22nd of September 1992, Ramkaran Gujar and 5 other men who wanted to punish her for this, they gang raped her in front of her husband. Now, the facts of the case are a little different because this is a criminal case. However, these facts did give way to certain issues, such as one, whether sexual harassment at workplace amounts to violation of rights of gender inequality and right to life of liberty, whether the court could apply international laws in the absence of applicable measures under the existing laws, and whether the employer has a responsibility when sexual harassment is done by one of either him or his employees. And the bigger issue is to provide a judicial process to prevent sexual harassment of women at workplace. Now, there were some relevant articles about this. One was Article 42, which talked about just and humane conditions of work and maternity relief. Then there was Article 15, which talked about the state not discriminating against any kind of sex. The Article 21, which talked about life and liberty, and then Article 15A, Part E, which talked about the dignity of women. The application of international laws was one important issue simply because there was an absence of any kind of domestic law which was concerned about sexual harassment in the workplace. And that is why international conventions and norms were significant for the purpose, for the interpretation of any kind of guarantee under gender equality. We will now talk about what sexual harassment is. Sexual harassment includes some such unwelcome sexually determined behavior as physical contacts and advances, sexually colored remarks, showing pornography, and sexual demands, whether by actions or by words. Such conduct can be humiliating and may constitute a health and safety problem. It is discriminatory when the woman has a reasonable ground to believe that her objection would disadvantage her in connections with her employment, including recruiting or promotion, or when it creates a hostile working environment. Now, there were a number of preventive steps that were provided in this case. One was that there has to be an express prohibition of sexual harassment. That is, it needs to be notified, published, and circulated in appropriate ways, which means that everyone in the workplace should be aware of the prohibition of sexual harassment. Then there was that the rules and regulations of the government and public sector body relating to the conduct and discipline should include rules and regulations prohibiting sexual harassment and providing for appropriate penalties in such rules against the offender. As regards to private employers, steps should be taken to include the aforementioned prohibitions in the standing orders of the Industrial Employment Standing Orders Act 1946. Appropriate work conditions should be provided in respect to work. For example, there should not be any kind of hostile environment towards women in the workplace. And no employee woman should have reasonable grounds to believe that she is disadvantaged in connection of her employment. Then we will talk about criminal proceedings. Now, where such conduct amounts to a specific offense under the Indian Penal Code or any other law, the employer shall initiate appropriate action in accordance with the law by making a complaint with the appropriate authority. In particular, it should ensure that the victims or witnesses are not victimized and discriminated against while dealing with the complaint of the sexual harassment, which is a very important thing. The victims of the sexual harassment should have the option to seek transfer of the perpetrator of, or their own transfer to stay away from that person. Then we talk about the complaint mechanism. Now, we have discussed how complaints would work, but the complaint mechanism is also relevant. Whether or not such conduct constitutes an offense under law or a breach of the service rules, an appropriate control complaint mechanism should be created in the employer's organization for redress of the complaint made by the victim. So, such complaint mechanisms should ensure time-bound treatment of complaints, something which has been prevalent in these situations where they do not follow a normal time for treating such complaints. Now we will talk about the complaints committee. The regulations under this judgment gave for complaints committees, which is that a provision of a complaint committee or a special counselor or any supportive services, it should be provided. Then maintenance of confidentiality, there should be a confidentiality of all the complaints that they go through. The committee should be headed by a woman, and no less than half of its members should be women. The complaint committee should also have a third party involved, such as an NGO, so that the possibility of influence from senior levels or any other senior person is diminished. The complaints committee must make annual reports to the government department concerned of the complaints and actions taken by them. And the employer and the person in charge will also report on the compliance of the aforementioned guidelines, including the reports of the complaints committee to the government department. Now we'll talk about the workers' initiative. Apart from these official procedures, there were also workers' initiatives enlisted in the procedures that were there. For example, that employees should be allowed to raise issues of sexual harassment at workers' meetings and in other appropriate forum, and it should be affirmatively discussed in employer-employee meetings. Then we have awareness. Now, the awareness of the rights of the female employees in this regard should be created in particular by prominently notifying the guidelines and the appropriate legislation when enacted on the subject in a suitable manner. There were other guidelines such as adopting suitable measures under central and state government, and also to not prejudice any rights available under the protection of the Human Rights Act 1993. And this is the end of the Vishaka versus State of Rajasthan. Thank you.